Representative Canton, I just want to know seats the vice chair. Yes.
Yes, so probably a question for the council, for JRC. As far as the regulations, obviously, through probate court, is that correct?
I'm sorry?
Probate court's involved in any kind of recommendations that are involved?
Yes, under the existing state regulations, if a school wants to use aversives on a student or an adult, you have to go to probate court, request permission to do that. A lawyer is appointed to represent the person you want to use aversives on, and there's a hearing held, and it's up to the judge to approve it or not approve it.
It is an independent investigator assigned to the case, is that correct?
Yeah, it's in the form, it's a lawyer. Yeah, but it's really more of a psychologist, an independent psychologist. You could call him a GAO.
That was my second question. Yeah. Whoever's appointed as an independent investigation obviously has the qualifications in that field to make an appropriate decision, is that correct?
Correct, a psychologist, yes.
And when that attorney is appointed or the GAO is appointed, what's the time frame between, and what is the consultation between the probate court, the investigator, the parent, to come to an appropriate recommendation or input, better said, for treatment?
Well, what typically happens is a student will be at JRC for probably a year before a decision is made to use aversives. More than half the kids ultimately don't need aversives. The JRC has an intensive behavioral program, and actually more than half the kids, just under that intense program, without any aversives at all, with just rewards and token fines and things like that, they ultimately don't need aversives, and they do extremely well. But if after those 12 months or so, a student is still hitting himself, still attacking, doing other terrible things, then the JRC clinicians will talk to the parent. Maybe we should be using aversives. We'll go through the peer review committee, the human rights committee. That'll take a while. Maybe the school district if he's under 22. If all those approvals are received, then it's filed with the court. The lawyer is appointed. First thing the lawyer typically does is come to JRC, visit with the student, maybe talk to the parent, sort of investigate the situation, decide if he needs an expert, request funds from the court to hire his own psychologist to look at it. And then after the psychologist, the independent psychologist has examined the case, then typically that independent psychologist will get together with someone like Dr. Blankish, one of the JRC clinicians, and they'll talk about the plan, maybe make some changes based on the input of the independent, and they'll either come to an agreement or not come to an agreement, and they'll present whatever their evidence is to the judge. So it's a long process. I mean, probably a year before even aversives are considered, and then the court process probably takes 3 or 4 months.
Okay, and after that 3 or 4 month period of time where there's a determination made, what is the review process on that? Is it something that comes back every 6 months, every year, when necessary? What are any concerns that a parent may have? What's the process from there?
The parent retains the right at any time to stop the treatment, even if the court approves it. Basically what the court's doing is giving the parent the authority to consent to the treatment. That parent can withdraw that consent at any time without talking to the court, the lawyers, anybody. But in addition to that, the law requires that that case be reviewed every year. And the judge, as they often do, can set shorter review periods. If there's a particular issue in the case, they can do it shorter. And the lawyer can bring that case to the judge at any time. He could bring it 2 weeks later if he wanted to. If he thought there was who represents the student. Yep, the patient.
So the review process, the attorney can bring that at any time?
Anytime. Anytime. But the way that typically works is if that lawyer has a problem, they'll come to JRC. I mean, they won't even come to me. They'll go directly to Nathan and say, I have a problem with something here. We need to determine if it's a problem and change it. And that'll happen. But if the lawyer's not satisfied with what JRC is doing, he can go right to the court.
Dr. McGuire had put some information in about fading. And what is the percentage of cases that have come back before that actually the fading process? Is there any statistical information over the past couple of years where that case has been reviewed and the aversives have been removed from that client?
Yeah, the statistic I read, the DDS report that has just come out that Dr. McGuire referred to, in that report contains a statistic that there are 63% of the people at JRC right now that are on GED. Now there's only about half that are on it, but of that half, 63% of them either have been faded or in the process of being faded. The way the GED typically works is it works very quickly. Within a month, the person is getting less than 1 shock a week. In fact, in that same report, the median, and in some cases the average, is really almost 0. it's just a tiny fraction of how many shocks that a student is getting per week. So the treatment itself has sort of this built-in fading process where close to 80% of the kids are within less than a month are getting almost, I mean, maybe 1 or 2 a year even. It just falls right off the table. Now, there are some cases, though, the really, really tough cases, where the individual, is just big and strong and tough and resistant to treatment. Those cases will take longer. And then there are even some cases of the severely mentally retarded kids, adults now, they may need it every now and then throughout their lives, just like they need to be in an institution because they're severely retarded, they couldn't possibly take care of themselves, or they may have a shunt because they have problems with fluid in their brains. So for a very, very tiny percentage of the severely retarded, they may need to have access to that device now and again, almost for their whole lives.
One more question. When New York State removed the aversives, was there any statistics done or any clinical information for what treatments were imposed relative to what Massachusetts is doing now?
Yeah. Well, that regulation, which included a ban in New York, was imposed, unfortunately, without any discussion with any of the parents. It was really, it's our position, that was a response to a lot of media attention on the use of aversives. And the parents in New York, 50 parents, filed a lawsuit in New York. 50 families, I should say, filed a lawsuit in New York arguing that, that these regulations violated their kids' rights because it was stopping treatment that their school districts had put into their IEPs. And that lawsuit is still pending. I'm representing the parents in that case. We're waiting for a decision from the judge. But what's interesting is that ban that was discussed, there's a grandfather provision in there. So the ban which went into effect this June 30th doesn't cover anybody that already, in New York, that already has aversives in their IEP. So it's somewhat unfair. It's saying, well, if you have them in your IEP already, you can have them for the rest of your life if you need them. But if you don't have them in now, you can't. But what's most interesting on that is their own expert in the litigation in federal court, their own behavioral expert testified that he disagrees with the ban. He thinks there are clearly some cases where aversives are necessary. And I can give...
What was implemented when it was removed from some clients when New York did? What were the next course of events, so to speak?
Well, what happened is, when those regulations went into effect, GRC actually had to stop using aversives, or really restrict the use with a bunch of kids. And probably 50 or 60 kids. And there was some immediate and dramatic bad effects. I mean, their behaviors were going through the roofs, the education stopped. And we were actually able to get an injunction from the federal judge after about 2 months of this, where he ordered New York State Education Department to not enforce these regulations, and we were able to get the kids the treatment again. And they're still on it to this day. But whether that's going to continue, we're waiting for the judge's decision on that.
Maybe when some of the folks from New York testify, we can get some information on what their experience has been. So, thank you very much.
Thank you.